Please stand every time you enter this court. We do that with respect. This courtroom is literally majestic. At the great state of Florida behind Your Honor is robed. We have two flags. The state of Florida flag and the state. This and I point that out to you, ladies and gentlemen, because you have sacrificed. You have sacrificed your time away from your family, time away from your job, time away from your pursuits, to be to sing. When we're in this hall, when we're here, not on the internet doing anonymous comments. We're not in some kind of chat room where everyone's spousing their opinions. Heard on and on about beyond and to the exclusion of a reasonable doubt. And I want to briefly go over that actual instruction, word for word. One of the things we've been doing, or you guys have been stuck behind closed doors, not pursuing your own interests, is we've been working on what exact words, what law, what language is what we can instruction on. And as you can see, a reasonable doubt, the defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving, and the state always carries that burden, of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. And they go out of their way to define it whenever the words reasonable doubt are used. And this is what I want you to pay attention to. You always hear, and it's common because it is within the law, prosecutors say a reasonable doubt, and we even have a slide from the state's presentation. Reasonable doubt is not possible, speculative, imaginary, or forced doubt. That statement is an accurate statement of the law. If you add the rest of the sentence, and the rest of the sentence is, ladies and gentlemen, if and only if you have what's called an abiding conviction of guilt, one which does not waver or vacillate, because if it does, even if you have a conviction, but it's not stable, it's one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt. And you must find the defendant not guilty because that doubt, which could be imaginary, forced, speculative, it's reasonable because you don't have that abiding conviction of guilt. An image I imagine most of us see. What do people see when they look at this image? Do they see two faces? Do they see a split face? When you have equal explanations, is it a vase beyond a reasonable doubt? Is it a fake two faces beyond a reasonable doubt? Ultimately, you all decide. You all decide should be walking with us today is no longer, is not, never will be. You can't swear. They gotta do it for you. They gotta do it for you with evidence. There are, in this case, two charges. One of the instructions, and I submit to you a very important instruction, that there are two separate charges. First-degree murder or deliberate assault. We have tried those counts together, honestly, to ultimately reduce the amount of time jurors would have to be in the courthouse. But they could have been tried completely separately. They could have been, a burglary could have been tried, a homicide could have been tried. We tried them together. Your verdict as to one of the counts has no bearing on the verdict as to the other. You are free to reject evidence. You are free to accept evidence. And you are free to determine that maybe evidence supports one charge, but woefully falls short as to the other. I want to talk to you a little bit and never let you forget this image as you think about the state's obligation. Because I want to talk to you about what their actual evidence was. And we heard, and I will tell you at the outset, probably should have started with this. You all are not making a determination in regards to Mr. King. Not tasked with that. No one's going to argue to you on that. Evidence is presented to you. Will convince you that the voice occurs guilty of two charges. So let's talk about what evidence actually applies. Leroy Whitaker and worthy of your consideration. And I would suggest to you are basically kind of four categories of what we heard that had any application in regards to Leroy Whitaker. We have DNA records. We have cell phone records. We have Abdul Robinson Sr., AKA Blue, and we have Dominique Barner. Let's kind of start with some of the most straightforward evidence. And I will say it's straightforward. The DNA evidence. Now you've got to consider what that tells you, what that helps you to determine. And we have two different kinds of DNA evidence. We have DNA evidence that was found in the car, and we have DNA evidence that's alleged to have been found in the property. Now, the DNA analyst, you will remember, was very, very clear. DNA is transferred. You might remember the example of I can hold an object, give that object to another person. They have it, and they place it somewhere I've never been. It doesn't tell us when DNA was left. It doesn't tell us how. You've heard this statistical time establishing IP addresses, who called who. Did we have that kind of testimony? In regards to this alleged phone used by Leroy Whitaker, was it spelled out for you? You're the fact finders. You all, evidently in evidence, look at these maps. What do they tell you? They tell you, and remember his testimony. I've drawn these maps, and I put up these arrows, and it's, anywhere in this area. 1.5 to 2 miles radius from where this election is. So is it truly helpful? Because let's think of these population centers. We saw from all the photographs how many people are out at that Merrill Road. And these phone numbers give us the exact location. Let's assume for a second you chose to stop as a group. The phone records are helpful. We think the phone records tell us where Leroy Whitaker's phone might have been traveling. Let's say we further even decide, you know what? I think that evidence was pretty compelling. I think it shows that it automatically, logically, beyond a reasonable doubt, is Leroy Whitaker? Without any other evidence? Think about all the things Detective Smith could have, but didn't, or maybe did, and just the evidence isn't available for this rifle. Because we know there's no fingerprints. We know there's no DNA on it. We know there was no search warrant for his home, any interviews of his home. We know he didn't attempt to trace this gun in any kind of way. And most importantly, you know the biggest thing you didn't have? This might have been a little helpful. He doesn't have an iCloud or a phone from Dominic Barnes. It is important to remember how and why Detective Smith explained that. Why didn't you get an iCloud for Dominic Barnes? Why didn't you try to get the physical phone by August of 2020? He's a state actually prove. To be a principal, it is far more another thing that I will tell you is probably the most telling from the Jacksonville Sheriff's Office. We heard a little bit about it yesterday. Is that as an investigative technique, Jacksonville Sheriff's Office can do something that's called surreptitious taking. So we have two suspects. They'll do this oftentimes when two people are arrested together. They might put them in the back of a police car, put them on the camera. Same with the interview rooms. Put them in there. And you heard the timeline. And the timeline is somewhat critical. August 27, 2020, Dominic Barner agrees to be a state witness, files a sworn statement. All of the arrest warrants are completed at that point. Jacksonville Sheriff's Office didn't charge Leroy Whitaker with murder until Dominic Barner said the magic words. But then you have them, right? You've got those magic words. Dominic Barner is now at your disposal. He wants to do anything. They put Dominic Barner and Leroy Whitaker into a room and turn a tape on. They could have. You heard from Mr. Barner, who's right next door at the Duval County Jail. Why wouldn't they want to? Absence of that evidence. Are you wavering? Are you vacillating? You don't get to the other side as swimming on a Dominic Barner. Because he sees that is. Another technique they could have attempted, and we heard they evidently thought well of it because someone wore a wire on Dominic Barner. Why not on Leroy Whitaker? Why not? We're about to charge a 19-year-old young man with first-degree murder that you've heard from Dominic Barner. He had to make sure that he cooperated. He did not want to go for mandatory life. He has to say something. And so it becomes Leroy Whitaker was involved. He was all in. I can't give you any details. I can't point to a text message. We just saw some text messages between evidently Abdul Jr. and Dominic Barner. Was Leroy Whitaker copied on that? Do we have text messages from Leroy Whitaker and Dominic Barner or anyone even mentioning Charles McCormick's name? Do we have any kind of posts that Leroy Whitaker acknowledges ATK, acknowledges Six Block, acknowledges some kind of rivalry? No, we've only heard they have a rivalry. They were upset about Willie Addison's death. What has been shown to you about Leroy Whitaker? Ladies and gentlemen, I submit to you nothing. We have magic words from Dominic Barner, not supported by a single other piece of evidence. I want to skip to this slide because it is an important instruction in that the framers that actually set out these instructions, and they spent a lot of time doing it, they actually put this in the law because it's that important, because they recognize that you must consider the testimony of some witnesses, snitches, with more caution than others. For example, a witness who claims to have helped the defendant commit a crime has been promised immunity or hopes to gain more favorable treatment in his case may have a reason to make a false statement in order to strike a good bargain with the state. May, as kind of an aside, because I know you guys have been here long, I'm going to tell you about my husband's and mine's first date. Because strangely enough, our first date was to see the movie Indecent Proposal. I don't know if you ever saw that movie. It was with Robert Redford, Demi Moore, and but essentially you had this married couple, and Robert Redford ends up propositioning them that if Demi Moore will have sexual intercourse with him, we'll give him. And I have to tell you, as a first date, it was kind of an amusing movie to watch. Prompted a lot of fun conversation afterwards, and we're still married, so it all worked out. But I think about that kind of scenario in the scene film. It's not mine. Something far more important. He's 31 years old. 20 years? Or we know it's much less than that. If he ends up getting 20, he's got 5 years left. He doesn't have any more mandatories, so he ends up getting out even less. He's still a young man. Well, he has to do, that's a long time to be in. What would Dominic Barner do? You know, he told you what he did back in the day. He was able to get probation when he testified against his friend Mark Clayton. Said, absolutely, willing to do it. I'm ready to get out of jail. Dominic Barner. Anything to get in. But he needs convictions. And he needs a lot of them. Because he's got 2 separate murders, he's got to atone for, he's got an aggravated fleeing, and he's got a burglary with assault or battery. Dominic Barner needs convictions. It's not going to be sufficient, not for his sentencing hearing that he has planned, just to say, oh, well, yeah, we went into the house. No, Leroy Whitaker needed to be part of it. He needed to be part of it so that Dominic Barner can have one more conviction to try to hang his hat on of why he should get out of jail. As he said, well, I think I should get the 20 years because I'm bringing justice for the family. And with that, you do have to recognize, and I mean this in all sincerity, homicide detectives work very, very hard. I'm confident of that. And I don't think Detective Smith is any stranger or anomaly of that. I'm sure he works extremely hard. But there is pressure on homicide detectives. Because as I asked him, they're the ones that have to go and sit down with the family to explain, your loved one's not here. And so there is pressure to get anyone that was a part of the death of their child. That pressure is understandable, but it doesn't erase their obligation that they do actually have to prove it. It's not enough to simply say, he was in on it. I'm sure there were conversations. Because at the very end of the day, ladies and gentlemen, even if you wanted to try to believe Dominic Barner when he claims, well, once we got to the apartment complex, there was this discussion that both Leroy Whitaker and the shooter were going to shoot. Both were going to do it. What do we know? We know Charles McCormick was killed by a lone gunman. So even if you believe every single thing the state has presented to you, the reality is he didn't do it. They've shown nothing, not through photographs, not through Instagram posts, not through phone calls, not through text messages, not even through Barner's testimony, any evidence that Leroy Whitaker had any intent for Charles McCormick to die. I am going to sit down in a few moments, and I ask you to indulge me for just a few moments while I go through my notes. Because let me tell you the worst thing for a trial lawyer, and it doesn't matter what side you're on. You sit down, and 2 seconds later, I'll think of something that I was dying to tell you that I just simply forgot. Another difficulty in terms of that lack of evidence, and reasonable doubt can come from it, there was zero investigation in regards to this car. And Detective Smith, again, was like, well, it had been gone for 2 months. But again, they're trying to ask you all to convict of the highest charge in the land on Dominique Barner's testimony alone. Nothing else they presented proves the principle or even alleges it. He didn't even have probable cause until Barner said those magic words. Why? Because being at the scene of a crime is not a crime. You need to do more. And they've literally not shown you anything. But why wouldn't? Detective Smith, you have this car that's stolen. 2 months ago, did you even bother to talk to the person who owned the car? No. Did you even talk to the last person who drove it to understand how exactly it might have gotten stolen and if there's any potential leads for us to figure out where this car was for 2 months? No. Detective Smith, you have, as a Jacksonville Sheriff's Office tool at your disposal, these license plate readers, various spots in Jacksonville that you just type in the license plate and it will tell you, hey, on such and such day at such and such time, this car passed this intersection. Here's a photograph of it. Is anything done like that? Would that have been helpful? Ladies and gentlemen, I suggest it might, because we have a complete lack of evidence. The most simple thing, and if you think about the allegations are that all of this involves this big drill music, rap music. Ever turn the car on and figure out if anybody actually connected it? No, our software can't do that. How about just manually looking if there's a phone attached? Not done. That's a lack of evidence, ladies and gentlemen. We have no evidence of social media posts of Leroy Whitaker, of rap lyrics of Leroy Whitaker, of notes in his phone of Leroy Whitaker, text messages bragging, none from Leroy Whitaker, text message to Leroy Whitaker, talking about McCormick, talking about being with them. None there. We have no evidence, besides Barner, that that's his gun. We don't have anything tying him to the gun. We have no investigation as to the serial number of where this gun came from, how it might have gotten into whoever's hands had it, how it got in that car. None of it. We just assume. It's almost as if Leroy Whitaker is almost a footnote, an afterthought. Oh yeah, and Leroy Whitaker. Oh yeah, he was all in. We don't have any actual evidence that he ever manifested any desire for Charles McCormick to die, that he ever did anything besides potentially sit in an Altima car. That's what they've shown you. Detective Smith told us all we ever asked from Dominique Barner was the truth. He didn't ask him anything. The last question that I asked Detective Smith, if you remember, because we had these questions about how even after arrest, the investigation continues. And on September 11th of 2020, Detective Smith had executed that arrest warrant that talks about phone records, that talks about DNA, and most importantly contains those magic words, because Dominique Barner has come forward. But if you remember, my last question to him was, after the arrest, number one, of Dominique Barner, did you, Detective Smith, ever sit down with him and say, okay, let's really talk about this. Let's make sure that there aren't any other investigative leads now that I have full access to you, like your phone or your iCloud or anything else. Never spoke to him. And even worse, I asked him, after that arrest warrant, did you ever, I know your investigation supposedly continued, did you ever develop any other evidence or theory of principle of Leroy Whitaker? And vacillate. Leroy Whitaker was involved in this homicide. Leroy Whitaker manifested some intent. We have no evidence of that. My greatest wish for you as jurors, after you ultimately leave our hall of justice, is that you feel pride about your experience. Pride of being part of the system that we all do cherish. Pride in a system that upholds the law and is bound by the law. And you all are bound by the law. The burden of proof in this case is beyond and to the exclusion of a reasonable doubt. And to illustrate just how high of a burden, really think that all of these things, if we were somewhere not in a hallowed hall of justice, and we thought to ourselves, you know what? 3 guns, 3 people, I think it's pretty logical that gun must have been his. You think, you know, their family, yeah, he probably did know what time of day it was. Those are all guilt, most likely. Legally, that's not guilty. Guilt, likely, not guilty. Probably guilty, not guilty. Possibly guilty, not guilty. Suspected, not guilty. Perhaps not guilty. May not be guilty, not guilty. Possibly not guilty, not guilty. Unlikely guilty, not guilty. Probably not guilty, not guilty. Less than likely guilt, not guilty. Not likely guilty, innocent. When the state falls short, ladies and gentlemen, your constitutional burden is to find him not guilty. On behalf of the now we urge you to follow the law.
All right, thank you, Ms. Schlax. State rebuttal close.